And Union Home Minister Amit Shah introduced 3 bills in the Lok Sabha to replace the Indian Penal Code, the Code of Criminal Procedure and Indian Evidence Act, which are all enacted during the British Raj in a complete overhaul of the country's criminal laws. The 1860 Indian Penal Code will be replaced by the Bharatiya Nyaya Sanhita. The Bharatiya Nagarik Suraksha Sanhita will replace the Code of Criminal Procedure, and the Bharatiya Sakshya will replace the Indian Evidence Act. All 3 have been referred to a standing committee for review. Mr. Shah announced that sedition law has now been repealed. The word sedition has been removed from the proposed law and replaced with Section 150, which criminalizes acts that endanger the sovereignty, the unity and integrity of India. Now, marrying a woman by concealing your identity or having intercourse under false promise of marriage, promotion and employment will attract up to 10 years imprisonment, with a bill that was introduced on Friday proposing a specific provision to deal with these offences for the very first time. Amit Shah has gone on to say that the centre's big move to overall criminal laws against women and children, and now offences, they will be taken as offences against the state. This is a jail term of up to 10 years for marrying women by concealing the identity. The new bill prioritizes laws for crime against women and children, murders and offences against the state. Fines and punishment for various offences have also been enhanced. For gang rape, the punishment can be 20 years in jail to a life term. The death sentence has been retained in the new bills for rape of a minor. The proposed law also says those evading arrest can be tried in their absence. The police have to furnish an update on the FIRs, or the first information reports, within 90 days, and an e-FIR can be lodged from anywhere. The search and challan prosecution process has to be videographed, and the proposed law also suggests 1 year jail for bribing voters during elections. My colleague Akhilesh sent us these details.
Sources are telling us that it's a complete transformation as far as the criminal laws are concerned. And this exercise was long pending because India got independence in 1947. But we were still carrying the laws which were made by the Britishers. In fact, the first serious attempt was made by former Prime Minister Indira Gandhi in 1967. That's what sources are telling us. In fact, now the Modi government had started this exercise in 2019. There were wider consultations with various stakeholders. In fact, Home Ministry wrote different letters to not only the Chief Justice of India, but also the Chief Justices of different high courts, also the Chief Ministers, governors, and etc. And all the senior lawyers, they were consulted. And the government of India received responses from all these sections. In fact, barring 2 states of Kerala and West Bengal, all states gave their suggestions to formulate these laws. So, after wider consultations, these, you can call it a fundamental reform which has taken place now. The 3 bills which have been introduced, the work was going on for a very long time. And the government says very clearly that the idea is to, not only to get rid of the colonial mentality, the colonial remains, but of course, to ensure justice for our poor people, because they do not get justice. When they go to the courts take a lot of time because of the complex criminal law system, and that's why a complete overhaul was needed. Now, coming to the question of sedition law, the Home Minister has made it very clear that the sedition law has been repealed completely. In fact, one new section, Section 150, has been introduced, which does not talk about the crimes against the government, because the sedition law was, if you say anything against the government, then you can be tried against sedition law. But now the new provision does not say that. You can say whatever you want to say against the government, but if you talk about disintegration of India, then of course this law will apply to you. Maybe it be secession or any other attempt by you or by funding. If you try to do that, then the new section will be applied to you. This is the basic fundamental difference between the old sedition law and the new provision.